Okay. All right. Good afternoon, ladies and gentlemen. We're here in the Franklin Circuit Court for oral arguments today on summary judgment motions in case number 21 CI 461, Council for Better Education versus Secretary Holly Johnson and others. And I think the case has now been fully briefed, and we've got, I guess, a full agenda here today to argue the motions, and we may have a couple of preliminary matters that we ought to address first. So why don't we start out really just so I know who all we've got with us here today by just asking all counsel to enter their appearances for the record, and maybe whoever is acting as lead counsel for each party can do that, and then introduce their colleagues who will be supporting them, but have the attorneys who are going to be making the argument maybe take the lead for each party. So let's begin with the plaintiffs, and so the Council for Better Education. Who do we have here today?
Good afternoon, Your Honor. This is Virginia Snell, and my partners, Sean Williamson and Mitzi Wyrick, are also on the Zoom call today, also representing the Council for Better Education. And I know Eric Harrington will speak next, and he will be making the argument for the plaintiff's side.
Okay.
Good afternoon.
Right. Yeah.
Good afternoon, Your Honor. Eric Harrington, and as my co-counsel Virginia said, that I'll be speaking on behalf of the plaintiffs in favor of our motion.
All right. And for the defendants, I guess we've got. Well, let's start. Why don't we start? I don't know. Let me ask if Secretary Johnson and the official capacity defendants, if they're going to take an active role in the oral argument. I don't know if they are or not. So,
Your Honor, I'm sorry. This is Brian Thomas here on behalf of Secretary Johnson and Commissioner Miller. Along with me are Robert Long, Bethany Rice, and Jen Stossberg. We are prepared to update the court today in regards to where the department is in terms of administering the program, but to answer any questions that the court may have. And Ms. Rice will be presenting any information to the court today.
Okay, very, very good. So we'll note that, and we are going to want to circle back to those issues before we wrap things up today. So we'll note that for the record, and I'll have some questions, I think, for Ms. Rice with regard to where we are in the process. So, okay. And who do we have for the Attorney General?
Your Honor, Christopher Thacker for the Commonwealth, the Attorney General's office. I will be arguing on behalf of the Attorney General's office today. I have in the office with me, but off camera, two of my colleagues, Aaron Soletto and Olivia Omlin.
Okay. All right. And for the intervening defendants?
Yes, Your Honor, Joshua House here for the parent interveners. Alongside me are Benjamin Field and then our local counsel, Matthew Doan.
Okay. And again, I think I signed that order on the substitution of local counsel, correct? So we're all up to date on that.
Yes, John, thank you.
Okay. All right. Are there any other parties who are going to be participating in oral argument today? Okay. We also have, I guess, as a preliminary matter, we should take up, we do have a motion from amicus curiae who seek to leave to file a brief, which they've tendered to the court. And I see Ms. Breitz on the call, and I don't know if she has anybody else with her, but I want to hear from them and obviously hear any response to their motion to file the amicus brief. So.
Yes, Your Honor, I'm Beth Bretz. I'm here on behalf of the 6 amicus who filed the brief. I think as the Attorney General has opposed the motion to intervene, but they acknowledge that leave to file amicus briefs is within this court's discretion. And since at least 1957, Kentucky has taken the position that amicus briefs are a commendable practice in the interests of justice, and this court has and others throughout the state have repeatedly allowed amicus briefs, particularly in cases of great public importance like this one. And I think then they argue, they have 2 points that are conflicting about the proposed brief. First, they claim that it's irrelevant to the issues before the court, or that it's prejudicial because it raises argument that the AG has to respond to. I mean, aside from the fact that they can't have it both ways, they're just wrong. They assert that the proposed amicus brief is injecting new issues into the litigation, and that's based on a mischaracterization of the brief. That we aren't asking the court to examine any questions of federal law. Instead, we're simply pointing to various federal laws that the court may take judicial notice of that on their face do not apply to private schools. And amici certainly aren't challenging HB 563 or the Educational Opportunity Account Program in their entirety. That's not our ability nor our intention. And we're not trying to intervene. We're simply seeking to act as amici to provide information that may assist the court. Instead of injecting new issues or making irrelevant points, we are fulfilling a crucial mission of amici briefs by contributing the particular expertise of the 6 amici that are involved in this brief to provide information to the court about the impact that voucher programs have had in other jurisdictions, experiences that the court may take into account and accord proper weight without broadening the scope of the legal issues to be decided. Most courts encourage amicus briefs to supplement the submission of the parties by avoiding duplicative content. And here we're basically contextualizing the impact of this court's ruling.
Okay. Well, let me say, you know, I haven't thoroughly reviewed the amicus brief, but I did, you know, attempt to review it quickly before we came in here, and it does raise some concerns on my part that we're injecting into the case some issues or certainly some arguments that were not necessarily raised in the complaint or in the motions. And so it's a little troubling to me in terms of, you know, the ability of the defendants to, you know, I don't want to put them in the position of having to respond to things that really are not appropriately at this juncture part of the case. I don't know that there's much, if any, prejudice to the defendants. I also don't know if there's, you know, if the court would really give much weight to those things that are newly injected. So I don't know that there may not be a whole lot of harm in letting it be filed, but I have some concerns, and I guess I'd like to hear from Mr. Thacker. I haven't seen, I guess you filed something recently that I hadn't seen yet. So I'll let Mr. Thacker speak for the Commonwealth on that.
Thank you, Your Honor. We did file a response in opposition to the motion for leave to file the amici brief yesterday afternoon. And in that fairly short filing, I think we make 3 points. One is procedurally to the timing. Today's hearing was set, I believe, back in July. There's been a briefing schedule in place since that time. If an amicus wished to be involved, we think it would have behooved them to file something before briefing had closed.
Yeah, I mean, typically at the rule on the appellate level is that I think the brief has to be tendered prior to the filing of the briefs on the merits, so the parties can respond to it if they have a concern. But go ahead, Mr. Thacker.
And so again, we think even though there is no rule in Kentucky civil rules regarding amicus briefs at the trial court level, but we think the reasoning of policy behind the appellate rule applies equally here. Again, if you're going to have amici weigh in, they need to do it in the course of normal briefing and not wait until effectively 3 business days before the hearing. We do also sort of object to the nature of the arguments raised. Again, the case law that talking about it, amicus briefs generally talks about when they are helpful in elucidating the legal issues and arguments for the court. You don't have to read the brief, you can just skim it and see there is no discussion at all of the Kentucky Constitution, no discussion of Kentucky law. It is to the extent that it has any role, I guess it may have been appropriate for a policy argument for the General Assembly, but I don't know how amicus or amici can come in and suggest they're playing the appropriate role of amicus and aiding the court when they don't actually engage the arguments the parties have made. And finally, I will, and we note in our filing that, frankly, the underlying, I guess barely underlying, but it's surface level suggestion that somehow the act we're talking about today has anything to do with racism is frankly offensive, I think, to the General Assembly and to the Commonwealth, and adds nothing whatsoever to this discussion. So we do object to the
okay. All right. Thank you, Mr. Thacker. Yeah, Ms. Bress, I'll let you respond briefly. Okay.
First, there is no rule about amici filings in the trial court.
Right.
And so you are free to allow them whenever you see fit. I mean, I just got involved in this case last week, so I did not know about it. So
right.
I can't really say a lot as to timing. Now, as far as the fact that we don't really talk about the Kentucky Constitution or the statute, if we did, then I think the Attorney General would, and maybe correctly, claim that we're trying to intervene too late in the case, and that's not really the purpose of amici. What we are doing is simply providing the context for how these voucher type programs have worked in other states. And we are not, and I apologize if the Attorney General thought that we were trying to say this is racist, but the fact of the matter is that voucher programs began after Brown versus Board of Education. That is not to say that all voucher programs have that intent or that they all have that impact, but there is some potential impact that is racial, that is based on income levels, that is based on people's ability to speak English, their disability. There are impacts of voucher programs. And that is the point that we're making is just, this is what has happened. And these are the resources out there that have studied this and have shown what has happened. For you to take or leave as you see fit.
Okay, well, I'll tell you what I'm going to do is I want to look at, obviously, I haven't seen Mr. Thacker's filing, and I have barely seen the tendered amicus brief. I'll take a closer look at both of those and issue a ruling. I will say that if I allow the filing of the amicus brief, which at this point I'm unsure about, but if I do allow it, I'm going to allow the parties or the defendant certainly to file a responsive memorandum because I think it does raise issues that were not before the court prior to the filing of the or tendering of the amicus brief. And I don't think it would be fair to allow it to be filed without any response. And honestly, I'm really Not sure it's appropriate at this juncture to file it at all, but let me look at that more carefully and I'll issue an order, a separate order on that point. And I don't think that needs to delay us. Just, we'll go ahead and move forward today with the arguments as scheduled. So I'll issue a separate order on that. Any other preliminary matters that we need to discuss before we get into the merits of our arguments here today? Okay, then let's go ahead and turn our attention to the merits of the arguments that are before the court and the briefing that's been done. And since obviously this is the plaintiffs have the burden here, we're going to have them go first, and then we'll let the defendants and interveners respond. And we'll at this time recognize, I guess, Mr. Harrington, you're going to take the lead for the plaintiffs, correct?
Correct. Thank you, Your Honor. If I may, before I begin, I'd like to also introduce a couple of my co-counsel who didn't get introduced.
Okay, certainly.
Fowler, Jeff Walther, and John Wood are also present.
Right.
Your Honor, under the Kentucky Constitution, as the Supreme Court made crystal clear in Fannin versus Williams, the Commonwealth is obligated to furnish every student in the state an education in the public schools, and it is constitutionally proscribed from providing aid to furnish a private education. The case can end right there. HB 563 establishes a system to provide aid to furnish a private education. The law specifically authorizes and creates the system and funds the system that will channel funds to private schools. The Supreme Court in Fannin made clear that the education clauses, when read together, prohibit money spent on education to be spent anywhere besides the public schools, in the words of the Fannin Court, exclusively in the public school system, unless the voters approve and say otherwise. Now, I'm sure the Attorney General and the intervening defendants will say, well, what is different here, what saves HB 563, is that the funding mechanism is a tax credit and not a direct tax or not a direct appropriation. In Fannin, picking up a long line of cases and in constitutional tradition dating back to the framing, said when they review a statutory scheme like this, this court is to look at the validity of the statute based on, not on the form of the statute, but on the substance of what it does. And no one can be confused here. The substance of HB 563, and in particular, the provisions that the plaintiffs asked this court to strike down, do what the General Assembly all must admit cannot do under the Kentucky constitutional system. It provides aid to furnish a private education. Our opponents may also say, well, it only counts if there's actually tax revenue that's come in. And in another case, the Kentucky Supreme Court has foreclosed that option. In Miller versus Covington Development Authority, the General Assembly passed what was then called the Tax Increment Act. And that act allowed school districts to forego future revenue. They didn't even collect any money. And the Kentucky Supreme Court said that that violated Section 184 because they didn't put that question to the voters. And the court in that case also said it's always been construed that money collected for education must go to the public school system unless the voters approve otherwise. In addition to the education clauses in 184 in particular, HB 563 violates the public purpose clause. Again, Fannin is crystal clear. Fannin says furnishing public aid to private schools can never serve a public purpose. regardless of whatever reasons or policies there may be. And recall, in Fannin itself, speaking to the issue of whether or not this sort of complicated scheme that's been developed in HB 563 as a workaround to the clear constitutional prohibition under both the education clauses and the public purpose clauses, the Supreme Court said, even if you're trying to loan books, in that case, in the Fannin case, the Department of Library didn't even give the books, didn't give any money, didn't collect any money. All they did was loan books to private schools. And Fannin said that that violated the public purpose clause. And that was true regardless of whatever reason or policy interest that the General Assembly might be trying to promote. At bottom, what the Supreme Court and what the framers have said, as the framers said at the time of the constitutional framing, the settled policy of the Commonwealth of Kentucky is to provide education through a state system. Now, we fully understand that the Attorney General and the intervening defendants simply disagree with the framers. They think a scheme like this would be a good idea. We think there's very good, and this is why the school districts and the individual plaintiffs are objecting to this. We don't agree, obviously, and we think that the proposed amici explain well why these kind of programs are just bad policy. But this policy debate is not for the General Assembly to have. It's not for us to have. The framers settled that policy debate, and they said it is the settled policy of the state to prohibit aid to private education. And one of the reasons they did that, and one of the key reasons they did that, is because they firmly believed that the way that it was the most vital duty of the Constitution and the General Assembly to provide education to all students, regardless of their economic station, regardless of their geographical location, and regardless of other reasons to exclude them. But the private schools that will be funded by HB 563, we know, will not welcome all Kentucky students. The law itself limits private school tuition to a handful of large counties. It specifically licenses discrimination. And we know that the schools will discriminate on the basis of disability status, on the basis of LGBTQ families, on the basis of religion. That licensing of discrimination is an anathema to the framers' vision for how education is to be delivered in Kentucky. And the Rose decision is clear on this. And our friends on the other side want to limit Rose to just a funding case. But the foundation of the Rose decision was the firm belief that the Constitution requires the General Assembly the highest duty, right, to provide education to all Kentucky students and to provide it regardless of their circumstance. And so that is the animating principle of the Rose decision. And HB 563 is in direct conflict with that.
Let me ask you how you respond to the Attorney General's and the interveners' argument from the Arizona case. I mean, obviously, they are arguing that that all of the cases that you're relying on and that you've very correctly pointed out to, there's a lot of Kentucky cases about aid to private schools in the context of public resources. But they argue that the Arizona case stands for the proposition that there's no tax dollars involved, and so that this is just essentially an act of private philanthropy that has nothing to do with the government. So what's your response to that, and how do you distinguish how do you distinguish the Arizona case, or how do you argue that it's not applicable to these cases?
I thank Your Honor for the question. I think I'd like to give three-part answer to that. The first, and Your Honor, put your finger on the first part, which is we're not working from a blank slate here. The Kentucky Supreme Court has very well-developed constitutional case law on the broad prohibition under the Kentucky Constitution that prohibits aid, public aid to private education. So we're not starting from a blank slate like in Arizona. And we think that, as Your Honor already alluded to, the right place to be looking, which is why we're talking about this is a Kentucky case under the Kentucky Constitution, and that's where we should look. As for the other states, I think there are 5 that are kind of that we should talk about. There are the states that held that tax credit schemes like this one that do not violate their constitutions. The 3 that I think are, I mean, I'm going to be clear, there are 5 cases, 3 that held that tax credits don't violate their constitution, and there's a couple that took a different view. I want to talk about all of them. So first, Arizona. Your Honor specifically asked about Arizona. The prohibition in the Arizona Constitution is on, quote, public money or property. In that case, it was a religious a prohibition on aid to religious schools. And the court looked at the terms of the Arizona Constitution, which prohibited public money or property, and concluded that tax credits were not public money or property. Similarly, in the Alabama Constitution prohibited appropriations. That's the language in that Constitution to private schools. And in Georgia, the language is no money shall be taken from the public treasury. And then finally, I guess it's for the Florida case is no revenue of the state. Now, why these are all distinguishable, as this should be apparent here from the language of their constitutions, is that the defendants want to read into the Kentucky Constitution the terms that are found in those constitutions, those limiting terms like appropriations or public property. But the Kentucky Constitution says no sums can be raised for education that don't go to the public schools. Much broader. And on top of that, the Kentucky Supreme Court has read it much broader and taken a functional approach to how the court should analyze public aid to private schools. Now, there are the 2 other sister states that have different constitutional provisions. And the most analogous to Kentucky's, both in language and in a constitutional approach, would be Massachusetts and Montana. And in Massachusetts, there, the Supreme Judicial Court, SJC, specifically concluded that a tax, in that case, a tax deduction that provided aid to private schools violated their no aid clause. And Montana had a provision that prohibited direct or indirect support. And they concluded that that violated their constitution. And then the final point to underscore here is that the constitutional approach, the functional approach that Kentucky has taken and how to review statutes like this is not the formalistic approach that Arizona took, that Alabama took, that Georgia took, that Florida took. It is the functional approach, rather, that Massachusetts took, where you look at the purpose and effect of the statute. And here the purpose is super plain. The purpose is to provide aid to private education. It certainly will have that effect. And if you look, and we talk about this in one of our papers, if you line up the various holdings and sort of contours of educational constitutional law, Kentucky and Massachusetts look very, very, very similar. They allow the same things, they disallow the same things. The only hole is whether a tax credit scheme like this one violates the Constitution. Massachusetts has already concluded it would. That's the only difference that we have found that's at all, not even difference, it's just undecided yet. But all the other areas.
What's the Massachusetts case?
It is the opinion of the Superior Judicial Court, if you'd like the citation. I can certainly give that to you as I'm scrolling through here. I can point you to our brief too. It's page 31. But
Yeah.
I actually have it in front of me, Your Honor. It's 514 Northeast 2nd, 353.
Okay.
And as we talk about our opposition, there are additional cases in Kentucky that, I'm sorry, in Massachusetts line up. So book loaning programs, unconstitutional, just like in Kentucky. And there are others. Certain kinds of aid for public or private school transportation allowed, others aren't. And Kentucky obviously has a very developed case law on that as well.
Right. Okay. Okay. And I guess to be precise too, the Arizona case really was deciding the issue of standing in federal court, which is.
Well, yeah, Your Honor, I want to be very clear. There are two Arizona cases here. There's the
Yeah.
Arizona Supreme Court case. That's the one that I talked about. The
Right.
Wynn case was the question of federal court standing. It is not, I mean, those are all very distinguishable. They are not construing specific state prohibitions on aid to private schools. And as Your Honor knows, I'm sure very well, federal court standing is it's a jurisdictional question. It's narrow. There's a very narrow sort of exception to standing under taxpayer standing to challenge Establishment Clause violations. The Wynn case is an exception to the narrow standing rules of federal court, applying the Establishment Clause exception to taxpayer standing. It's like 3 steps removed from the issues in this case.
Okay.
And to the point here on the Wynn case in the other state courts, no court is announcing, as the defendants would like us to believe, that tax credits are a universal rule to get around no aid clauses. That if you just do it by a tax credit, no matter how robust the prohibition on aid to private schools is, you tricked it. You got out of the prohibition. And there's actually one more really important piece here that I want to make sure that we emphasize. There is Kentucky statutory law that was passed this year with right at the same time as HB 563 that makes clear under Kentucky state law, tax credits are expenditures. So even this language, how we get into whether it's spending, whether the prohibitions on spending, this is a spending. Expenditure and spending are synonymous. A tax credit is a tax expenditure. And remember that in Miller itself, sorry.
What statute or what bill are you talking about?
I'm talking about the budget bill that specifically describes a tax credit as a tax expenditure.
Okay.
And I have that for you as well, if you'd like. So 18 RS HB 200, that's just the most. That's the one from 2018. There's another one from this year. These are budget bills that get passed. And it in fact requires, and the Department of Revenue can speak to this, it requires them to prepare a report.
Well, yeah, I mean, we I guess you all filed the most recent state budget director's report on tax expenditures. So
That's right.
Okay. But you're there, I just wanted to make clear what you're referring to the language in the budget bill that talks about tax expenditures essentially as how they're defined under Kentucky law.
Yes, and to be clear, and here's the language.
Your all's position is it's clear based on that the constitutional prohibitions on no aid to private schools fall within that statutory definition.
Yes, but to be clear, Your Honor, we don't even think you need to go that far. Fannin makes clear that the prohibition on aid is very broad, and you look to the purpose and effect. You look to look through the form, as they call it, of the statute to the substance. All of this formalistic fight that the defendants want to have is just not the doctrine. And even if it were the doctrine, we would still prevail on the formalistic fight because tax credits are expenditures under Kentucky law. So it's really an argument in the alternative.
Yeah, but I mean, your all's basic argument on that point is that that the legislature can't do indirectly what the Constitution forbids it from doing directly.
Right. And we can just be very commonsensical about this. Everyone agrees the General Assembly could not send a check to a private school. But the defendants say what they can do is they can set up a middleman, what they have created and authorized. They can create this really, really irresistible and attractive tax credit that if you're wealthy and you've got capital gains, you'd be kind of crazy not to use. And they set up the law, they set up the tax credit, they encourage it, they decide who gets it, and then they funnel the money through there, and then they can say, oh, we didn't violate the no aid provision. that's clearly clearly a type of aid, and just is something that Fannin took on directly and said, you can't kind of create a complicated scheme to get around this. If anything, it reveals the constitutional problems. It does not hide them. Unless Your Honor has further questions, I'm happy to rest there. And
Okay, all right. No, well, I'm sure we're going to have other questions that will arise after we've heard from the other parties, and we'll come back to you to discuss those things. But it's probably helpful if we go ahead and move along now and hear from the defendants or the interveners. I don't know who wants to go first.
I can go first, Your Honor, assuming that the Attorney General is okay with that.
Please go ahead.
Oh, yeah, that's fine, Mr. House.
Thank you. Well, the only one thing needs to be decided in this case, and that's, can Kentucky create this tax credit? As even the plaintiff's brief acknowledged, taxpayers can already donate to nonprofits. Nonprofits can already use donations to aid needy families. And families can already spend their own money at private schools or homeschooling or on any other educational service. All of those already exist in Kentucky. The only thing that HB 563 does is create a tax credit where there currently is a deduction. There's already a deduction that people can get when they donate to these nonprofits. So the question for this case, and the only question before the court, is creating that tax credit constitutional? I want to take off from where Mr. Harrington ended, which is to say that this is not a sort of simple trick that sort of allows dodging some constitutional prohibition. This is just how constitutional law works, that the state can do some things through tax benefits that it couldn't do directly. We point the court to a case as classic as the Waltz case out of the US Supreme Court, which had to do with tax deductible property tax deductions for churches. If the government started giving money straight to churches, that would certainly raise constitutional establishment clause problems. But the court said in that case that it was completely fine to provide a tax deduction, or in that case, it was an exemption. And let me read the text. And this is at our reply on page 4. It says, quote, "The grant of a tax exemption is not sponsorship of religion, since government does not transfer part of its revenue, but simply abstains from demanding taxes."
Yeah, so let me ask you about that, Mr. House, because this is a conundrum for me. You know, it does seem to me like a tax credit is qualitatively different from a tax deduction in this sense. You know, and I struggle with the characterization of these donations to the AGOs as being private money, because I struggle with the idea of where does this money come from? You know, and this money at least appears to come from the taxing power of the state. That it is all this fund of money is only created because the income tax imposes a tax liability on taxpayers to pay an income tax, and that's where the money is coming from. So it troubles me a little bit to characterize that as a private donation, because you know it's one that's really it's not a donation in the sense that it is a liability that has been imposed by the state, and then the state has given the taxpayer the option of, you know, transferring that liability or making it available for a donation to a, you know, a worthy cause here in terms of, you know, helping educational entities. But it's created by the taxing power of the state, and that doesn't seem to fit the model of a private donation that these donations have been characterized as.
Well, here's why a tax credit is a private donation. That's because it doesn't have to be used. If no one claims this credit, the state is not funding anything. Like nothing happens. The state is not providing any money to anyone. The state can't account for this on the spending side of its ledger. It simply says when it looks at the revenue side one year, we took in less money. It's not accounting for, it keeps track of which tax credits are being used, but it's not keeping track of, what individual people, it's not telling individual people what to spend their own money on. That's the distinction. And that's this is black letter tax law. There is no case in the entire country that has held to the contrary. We pointed to the US Supreme Court case of Wynn just as an example. But if you look at you look at the IRS code, it says a tax credit is revenue is not being taken in. If you look at Kentucky, the very statute that Mr. Harrington pointed to, that actually supports our argument. A tax expenditure like this tax credit or like a deduction and like an exemption basically says we're not getting this money. This is not state money. It never enters the state coffers. There was a donation made by someone for whatever reason. And so we no longer account for just taking this money in. And that's exactly why tax credits for, say, donating to post-secondary school tuition of your employees, or tax credits for helping your employees attain GEDs are not unconstitutional either, because these programs, are just letting those private employers do with their own money what they want to do and then providing a tax benefit. But there are billions of dollars in tax benefits that Kentucky taxpayers are eligible for. None of those are being challenged on the face of the complaint. It seems that the plaintiffs really just have a problem with aiding low-income families with their education rather than with tax credits as a whole or tax benefits as a whole. But taken to their logical extreme, or just their logical end, I should say, all of these arguments that they've made would apply to the billions of dollars in tax deductions, and at the very least, the tax credits that Kentucky offers. Now, I think, again, because this is a tax credit, I think it's worth going through why tax credits are not regulated by any of the provisions that were brought up by the plaintiffs in their complaint. And going through, I think, one by one will be helpful.
Okay.
So first, plaintiffs raise 183, which requires, of course, the General Assembly to provide for an efficient system of schools. But providing a tax credit doesn't change or detract at all from the provision for common schools. And of course, 183 doesn't have any sort of prohibition in it about what parents spend on with their own money, whether homeschooling, private schools, or as a supplement to a public education. Section 184, the next section raised, is similar. It says it prohibits the General Assembly from raising taxes in order to support non-common schools, unless that taxation is ratified. Again, no taxation here doesn't apply. We can move on. Looking at
but again, we kind of get into this issue of is it the taxpayers' money or is it the public's? It's money that's owed to the Commonwealth in taxes, correct?
Well, no, Your Honor, it's not. It's not. This money's not calculated until it's tax time. So I could donate there.
Well,
I could donate here.
When you fill out your tax form, there's a line there for what your income is, and then there's a line of what your tax liability is. And if you get to get a credit for a donation, it's only by virtue of the fact that it's a liability that you owe to the state, that money is available, right? Talking about people who will be donating to AGOs to fund this program, I guess to the tune of $25 million a year for 5 years. Those are people who, by definition, they're not willing to make donations to these entities unless they get a tax credit, because they could make those donations right now and get a deduction like everybody else gets, right?
Yes, that's absolutely correct. But again, looking at this money, when you say that money, that's really the state's money that the state is letting them.
What's money that's owed to the state?
Right, but that could go for any dollar bill in my wallet, right? You could say that any single dollar bill inside my wallet is owed to the state, and it's only through the state's beneficence, through tax credits or through its favorable tax policy, that I get any of it. And again, every single court has rejected that proposition. There is no exception to that. The fact is that the money in my wallet today that hasn't yet been taxed is my money.
Yeah, well, but at the end of the taxing period, you owe 5% of it to the state if it's income, right?
Sure, but what 5%? Is it the 5% that I donate to my church? Is it the 5% that I donate to a nonprofit that helps lower income families? Is it which 5% is, and again, if you were to put a tracking beacon on each of the dollars in my bank account or a Kentucky taxpayer's bank account through the operation of this program, not one of those dollars is going to end up in state coffers. And that's the important part, is if you go through each of these provisions, so for example, 184,
Right.
it has to be taxed. It has to be collected. If it's not taxation, 184 simply doesn't apply. We never get to discussing whether it's for an educational purpose or not. And the same thing happens with
doesn't the Constitution talk about the levy and collection of taxes? So if the tax is not levied, there would be no money available for this program, right? It's only because the state has levied an income tax that there's a fund of money available to fund these this project.
Well, as the plaintiffs concede, though, again, this program can exist now. This entire process can exist without any state intervention. All the question is whether the tax credit is constitutional. So this act of donating private dollars, it's not the tax credit that gives me the power to donate. It's not the tax credit that gives the AGO the power to take money and give it to lower income families. Yeah. And it's not the tax credit that it's simply a benefit, an ad hoc benefit to the taxpayer on the front end. And again, we already do this for donations to churches. We do this for lots of things. And again, it matters because if you track those dollars, if none of them are taxes, if none of them are spending, we'd never get to the part of the analysis that has to do with purpose. So that means the public purpose clauses, for instance, are also not going to be implicated by this.
Because in your view, it's all private money, right? I mean, that's.
Yes, Your Honor. And again, that's the view of every single court to have considered this question. Mr. Harrington brought up two cases. He brought up a case from Massachusetts and a case from Montana. Now, the Massachusetts case, it's not really a case. It's actually an advisory opinion. It's not presidential in Massachusetts. And
they do things differently up there, right?
Well, and what's interesting about that case is that, first of all, the no aid provision that Mr. Harrington brought up, saying it was analogous to Kentucky's, I mean, Kentucky doesn't have a no aid provision. It's interesting that Mr. Harrington sort of analyzed the text of these other states' constitutions without actually looking at any of the text of the provisions here in Kentucky. None of those provisions in Kentucky say something to the effect of no aid to a non-state-owned organization, which is the language used in the Massachusetts Constitution. And again, it's not even, Massachusetts doesn't even leave it there. It says no aid for the purpose of. Well, that means that Massachusetts and Montana did something similar here, can say even private money, even programs incentivizing private donations could violate because that provision, because they have that purpose. But in Kentucky, the analysis is first, is it a tax or is it spending? And only if so do we get to the purpose. So look at, for example, Section 184. No tax shall be raised or collected until for the purpose of non-common school education until that taxation is put forth in a referendum. Again, the analysis is there a tax being collected or raised? And then second, okay, if there is, what's the purpose? And I feel like, I think what Mr. Harrington was doing was sort of doing that backwards, following the Massachusetts language, which is focusing on the purpose first. Now, Kentucky simply does not have a provision that says there is no public aid to a private institution. That's just not present. And of course, we know this from the transportation cases, allowing transportation services for private school students. We know that the rule can't be as black and white as the plaintiffs are suggesting. Now, the two cases, they going back to the second case, the Montana case, again, that one is similar because as we set forth in our briefing, in Montana, this provision was so broad that the court very clearly says it even covers the private donations or private contributions is the language in that case. So again, those cases didn't decide that tax credits are spending. What they did was they said, look, even if they are private spending, not government spending, our provisions still cover them. So the two questions that Mr. Harrington, brought up, the two cases were the Fannin and Miller cases, and they sort of rely on these cases as a way to avoid the text of the Kentucky Constitution. But those cases are actually some of the most helpful cases for our point, which is that in both of those cases, they involve the government taking money and spending money to benefit private schools, or actually the Fannin had to do with benefiting private schools. Miller had to do with benefiting a local developer who got to develop a local area.
Yeah, I guess in Miller, the public school district was required to forego a stream of property tax revenue, right? So
that's right, and it wasn't even foregoing a stream, like a future stream. It was committing basically. We're only going to take in so many. It was a tax increment financing scheme, so they're only going to take in up to a certain threshold. Anything we collect on top of that, we're going to give to you. That is money that enters the coffer of the school and then goes to a private developer. Of course, that would violate 184. 184 says if you tax for common schools, you got to spend it on common schools.
yeah,
That's not what was happening in Miller. And again, Fannin is similar. Those cases both have to do with public expenditures. And so just to return to where I started, this case can just end there. This tax credits are not spending. There's no government expenditure. There's no tax credit. And importantly, the plaintiffs don't provide a defining line for why, if HB 563 is unconstitutional, do the other educational tax credits not also violate the Kentucky Constitution? And why don't other charitable donations also violate the Kentucky Constitution? So for those reasons, we ask.
what's your view of the argument of the plaintiffs with regard to this issue of if it's a tax expenditure under Kentucky law, then that triggers the prohibitions of the Constitution, because certainly there is language, I think, in every budget that defines a tax expenditure, which may well be applicable. How do you distinguish that, or how do you argue that shouldn't apply?
Well, no, Your Honor, they're absolutely correct. This is a tax expenditure, but tax expenditure is a misnomer. Expenditure doesn't mean spending. Every tax lawyer will be able to tell you this. It's black letter tax law, and again, we provide citations both to Kentucky law as well as to the federal tax code. A tax credit, like a tax deduction, like a tax exemption, these are all tax expenditures, are revenue losses. They are not government spending, and without them being government spending, there's simply no trigger here for any of the provisions raised by the plaintiff's complaint.
Okay.
So unless the court has further questions.
Well, I wanted to ask another on another topic before we leave you. I also have a concern, which, and there's some discussion of this in the briefs, about the I guess the structure of this bill in terms of how the benefits are allocated, and the provision in the bill which basically limits the tuition assistance program to counties with a population of 90,000, which I think raises a concern, in terms of the special legislation provisions of the Kentucky Constitution, and it's a little difficult for me to discern the rational basis for that 90,000 population limit for counties to participate, for the families in those counties to participate and get the benefit of a tuition tax assistance when 111 other counties the families will not be eligible for that kind of assistance. So could you address that concern?
Sure, Your Honor. And the good news is that the court doesn't need to address whether there's a rational basis for that, for the simple reason that none of the provisions raised in the complaint have to do with a county by county sort of discrimination situation. If anything, that the population restriction would seem to implicate Section 59. Plaintiffs didn't raise that in the complaint. That argument's been totally waived. But even if they had raised that, As we point to in footnote 5 of our opening brief, there are many cases in Kentucky that say that population of counties is an appropriate basis for distinguishing the applicability of a statutory scheme. And just finally, one final point on that is that KRS 446090 says that the remedy here would just be to strike out the population restriction, and the rest of HB 563 would move forward. The quotation from that statute is, "It is the intent of the General Assembly in enacting any statute that if any part of the statute be held unconstitutional, the remaining parts shall remain." So I don't think this court needs to reach the question, but even if it does, striking that small portion of the statute will not remove the tax credits that HB 563 puts into place.
So again, but I'd still like to get your view of what's the rational basis for that population distinction.
Early on in the
for limiting that to those counties.
Early on in 563, I mean, in the text, I should say, I believe that the rationale is stated as because those counties, the larger counties have enough public schools for there to be private schools for there to be a private school infrastructure that can serve the students who receive these tax credit eligible donations. That seems to be the basis for it. And the Board of Education of Louisville case, again, that we cite on footnote 5 of page 15 of our brief, it says that with respect to the regulation of education and school districts, that these distinctions between the size of counties, population was rational. So this is certainly not out of the norm for Kentucky law, even in the education context, for these laws to apply differently based on the size of the county.
Yeah, but I mean, there are counties all over Kentucky that have private schools that have slots. So, in this county, there are 3, excellent private schools that appear to be excluded from this bill. And I guess I'm still trying to figure out what the basis is to exclude the schools in counties like Franklin County.
Well, I know that the bill itself says that decision is going to be reviewed in a year, and whether it's expanded or not, I guess will happen then. But the rational basis of this idea of there being a private school infrastructure seems to be sort of a question that the legislature is going to take a look at, that they did take a look at. I don't know that. Well, again, this court even has to.
It's not a mystery, is it? I mean, private schools are licensed and regulated. I'm sure the Department of Education has a list of probably dozens, if not hundreds, of private schools that are available. Many of which are in rural counties.
Your Honor, again, I understand the court's concern. I think it's pretty common for these sorts of regulations to exist in Kentucky. But again, the court luckily doesn't even need to address the question. It was not raised in the complaint. It's not an issue in this case. And these hard questions can be sort of pushed for another day.
Yeah. Okay. All right. I guess Mr.
I think I'm up, Your Honor. Again, Christopher Thacker, Attorney General's Office for the Commonwealth. And Your Honor, earlier when I was introducing our office, I forgot to mention that Victor Maddox is joining us by Zoom, just for the record.
I thought I saw Mr. Maddox's spot on the Zoom call, so glad to have him with us.
Your Honor, I'm going to try very hard not to repeat everything that Mr. House addressed, because the Commonwealth does agree with the arguments he's made, and as the court knows, you've got about 500 pages of briefing, so I don't want to belabor what's already before you. I will pick up where you left off, and again emphasize that just last year in Callaway County Sheriff's Department versus Woodall, the Kentucky Supreme Court, to the extent that the court believes that it needs to address the Section 59 argument, and again we agree the court should, and it's not in the complaint, it's waived, but to the extent it's been raised, I will note again the test under Section 59 now is again simply the rational basis test, and simply whether or not you've identified as a specific particular place or person, not a category. And so having categories is no longer a problem under Section 59. The rational basis, again, is stated by the General Assembly in Section 7, subpart 2B. And again, what they say is that because counties have access to substantial existing non-public school infrastructure, and there's capacity in these counties to either grow that existing tuition assistance programs or form new nonprofits from existing networks that can provide tuition assistance to students over the course of the pilot program. So particularly in the light of the fact that this is a 5-year statute, Your Honor, it's a pilot program. It might not be what I would have done. It may not be the best policy, but there's clearly a rational basis of saying, hey, in these larger counties, they already have private schools. We don't want people go out and starting private schools, or for that matter, private tutoring programs or AGOs to provide laptops just for the next 5 years if the infrastructure is not already there. That seems to pass that fairly low.
Seems like it would have been a rather simple drafting exercise, though, to say that tuition assistance is limited to those counties that have a private school available. But as I said, we've got 3 of them here in Franklin County, and I guess the families in Franklin County are out of luck if they want to participate in the tuition assistance program.
In Your Honor, I, as a matter of policy, I don't know that I disagree with you, but the Kentucky courts have said, in I believe it's Coupin versus Fitzgerald, says the General Assembly can have the leeway to experiment with pilot programs. That was the family court case.
Yeah,
you didn't have to have family courts in every circuit.
That experiment lasted about 20 years, didn't it?
Well, but again, there's.
Well, I understand. I understand that that's an area where there can be an attempt to try to do something new or something different, and this may fall into that category. So, and again,
given the very low threshold of rational basis, I think it passes. If it doesn't, Your Honor, again, we would agree. The remedy would be to strike the limitation to counties above 90,000 and make it statewide.
I tend to elicit a lot of criticism from some members of the legislature, though, when I take it upon, who think I take it upon myself now to rewrite their statutes. So does not seem to be a very appealing judicial act in current environment. But
again, as we know, they're brief, Your Honor. The law does, the case law does say that that severing,
that would pretty substantially rewrite the impact of this statute would be much different if that limitation was stricken from the law and the rest of the law was upheld, though.
It may or may not. I don't know that we can know that at this point, Your Honor. But,
okay.
But moving on, I do want to, again, try not to belabor or repeat points, but at the heart of this bill, I mean, the General Assembly does tell us their purpose, and I think particularly at this juncture, as a facial challenge, there's actually no reason to question or second guess their statement of purpose, as I think sometimes plaintiffs may want to do. The purpose is not to support private schools. The purpose is, and it states that at the very beginning of Section 5, the purpose of the Educational Opportunity Account Program is to give more flexibility and choices in education to Kentucky residents and to address disparities in educational options available to students. Right. And I think to an extent, plaintiffs have acknowledged that by, I think, dropping their challenge to the program as a whole. And as I understand at this point, there's no question that from the plaintiffs, the program can go forward, and you can have a nonprofit to provide laptops to qualifying public school students who can't get them now, public school students, or tutoring, or SAT prep. So
I guess that kind of raises the other concern I wanted to explore with you, Mr. Thacker, and with the other parties as well. I guess the concern that raises in my mind is the potential for this program to, essentially create kind of a two-tiered education system in Kentucky. That obviously the common schools are available to every student, and that's the whole purpose. I think what Rose said is that the legislature has an obligation to provide an efficient system of common schools that provides an adequate and an equitable education. And here we have a program that allocates, $25 million a year for 5 years to give the students who are lucky enough to be able to participate in that program additional assistance, which, I'll be the first to say it's wonderful. As many kids as can be helped, I want to see helped. But by the same token, it does raise a question in my mind under the Rose case and under the Constitution, is the question of whether we can have an educational program in Kentucky that is by definition limited to a small minority of students, and that gives them additional advantages in the educational endeavor that are not available to the rest of the school students in Kentucky. And, it kind of seems like if there is a need for this, that's an indication that maybe we haven't done what we're required to do in terms of making that efficient system of common schools available to everybody. So the potential for this, it's not potential. It's clearly, I think, going to happen. There's going to be a small subset of kids in Kentucky who will get the advantage of this, and the rest of the kids in Kentucky are going to be excluded. And I guess my concern to some degree is that the kids who won't be able to take advantage of it will be the poorest kids, the kids who don't have parents who are sophisticated enough to know how to apply for these grants and how to get these grants. That is troubling or problematic to me, the potential and almost inevitability that this will kind of fuel a two-tiered system in which educational opportunity is not equally distributed to the kids who need it most. So that's a concern I've got, and I'd really like to explore your all's response to that concern.
Your Honor, I would say a few things. That first of all, again, this is not a Section 183 or Rose type case, because 183 and Rose addressed the necessary conditions and the General Assembly's responsibilities to the common school system. This statute does not do that. It is not the school funding statute. It doesn't affect SEEK. In fact, the same General Assembly that enacted the statute meaningfully increased SEEK funding. So as a technical legal matter, we're not under that 183 Rose framework. Having said that, I actually think this statute is very much in the spirit of Rose. Rose spoke about giving the poor boys in the hollers the same opportunities that those in the cities had. And I think the impetus of this statute, which again has very clear income limits and even more aggressive income preferences. It is for not just lucky students, but low income students. And what the intent of the program is, to the extent there's abstract concern about dual systems of education, well, again, this bill doesn't create any new system of education. There already is a system, a network of private schools in Kentucky. They're Catholic schools, they're private schools that we're all familiar with. What this program does, to the extent it addresses school tuition, again, that's not all, but that's now all that's being challenged, is give the opportunity for some children of low-income families in our inner cities and our more urban areas the opportunity that wealthy families already have to send their children to private schools. And I think that's exactly the kind of egalitarian purpose and clearly legitimate public purpose. The fact that it doesn't give that opportunity to everybody, I don't think it's problematic. It's no different than the Keyes scholarships at UK. Resources aren't there. The General Assembly might, I can't speak for them, may want to make a complete school choice available to everyone without limits, but there's a reality that resources are limited. And so I think the goal here is, again, certainly not contrary to anything on the Constitution, and again, not contrary to the spirit of Rose. In moving from that level, I do want to talk a bit more about the means, because the court had some questions about.
Yeah.
Okay, so the General Assembly wants to increase the opportunities for low-income students, opportunities of various kinds. And in particular, we're now talking about the tuition assistance. The question then becomes, has the General Assembly done it in a permissible or constitutional way? Again, I don't want to repeat everything that Mr. House said, but I do want to push back on a comment that Mr. Harrington made or note when he was talking about the Massachusetts advisory ruling and the fact that in Massachusetts they have I think he used the phrase a functional approach to the constitutional provisions, and somehow suggested that that is the approach that Kentucky courts would or should take, as opposed to the adherence to the text of the Constitution, which is the approach that every other court in the U.S. Supreme Court in the Montana case that we spoke about earlier had. Again, that appeal to a functional approach is contrary to Kentucky contemporary current Kentucky jurisprudence, particularly in more recent Supreme Court decisions. Again, you look at Woodall, which you spoke out earlier, any number of text. You look at the text. You don't look at our attempt to construe what the policy the framers are trying to get at, which is basically, I think, what plaintiffs do. In the text here.
Let me ask you about that, though. I mean, in terms of the text, and this is one of the things that troubles me about the case, the provisions of the Kentucky Constitution with regard to taxation are chock full of restrictions and prohibitions that are designed to promote uniformity and equality in taxation. I don't think there's any question about that. And in section 171, we've got the provision that says all taxes shall be levied and collected by general laws. And it troubles me a little bit that we've got a general law here, the income tax, in which the legislature is now saying, if you take the liability we're imposing on you, we are levying this income tax. But if you want to make a donation to an organization that promotes private education or whatever, we're going to let you opt out of the income tax. You don't have to pay the tax if you make a donation to a group that we favor, and that tends to undermine, in my mind, the requirement of a general law. If you've got a general law that the legislature can essentially exempt certain people from, it's no longer a general law, and that's a pretty direct issue of interpreting the text of the Constitution. And so I'd like to get your all's view of how can you interpret that requirement that the levying of taxes has to be done by a general law when we've got a law here that allows people to essentially exempt themselves from income tax.
Your Honor, the Kentucky Supreme Court has held in Reynolds versus Martin. We cite that on page 18 of our response to summary judgment, that section 171 and its text specifically refers to taxes upon all property. It does not refer to income taxes. And the court held in Reynolds that, quote, an income tax is not a property tax and so is not subject to the uniformity provisions of sections 171 and 172 of the Constitution, nor is it governed by the provisions as to exemptions in section 170. In fact, Kentucky did not have a state income tax until 1936, I believe. I will also
Right,
say,
but the Constitution provides for an income tax. It leaves it up to the legislature.
but those equality,
Yeah,
Sorry, Your Honor.
but the provision I'm asking you about, it talks about property taxes, but it also says all taxes shall be levied and collected by general law.
and this is a general law, Your Honor. Anyone can apply for these exemptions. It's in that regard, and I think this is a key point that goes back to your prior discussion. There is no legal constitutional principle difference between the deduction here, or excuse me, the credit here, and the deduction that already exists and has existed in Kentucky law for decades. I'm not sure when Kentucky adopted the federal mirrored the federal tax deduction for charitable deductions to education, but it's well enshrined in Kentucky law. The only difference is the amount here. So today, if I write a check to either directly to a private school or to a grant-making body that funds private schools,
You don't have to include, you don't have to include, that's not included in your income.
It will be
You get a deduction. You get a
it will be
deduction. for that.
it will be deducted from my income
Yeah.
before my tax liability is concluded. The same thing happens here. I don't owe a penny to the Commonwealth for my taxes until I fill out on income tax, until I fill out the income tax form, and we calculate at the bottom based on income, deductions, credits, and a bunch of other stuff.
Yeah,
At that point, so the government, and I'm going to push back against this idea that plaintiffs have that basically the government has a right to everything in my wallet, and what's mine is just what they say I can keep at the end of the day. Well, no, until my tax liability is actually calculated, it's my money. Only once my tax liability is calculated and due does the Commonwealth have a vested interest in it. And that's true. The same for the 5% deduction.
you're saying that in terms of that theoretically, there's no theoretical distinction between a deduction and a credit.
That's right. The way it works in terms of who owns the money, whether it's state money or my money or the donor's money, is exactly the same. The only difference is the amount. And plaintiffs have not even attempted to make a principal argument as to where between 5% and 95 do you get a constitutional problem? And you don't, because the Constitution, Kentucky's Constitution, talks in terms of the General Assembly, again, levying taxes and then actually paying them over to a private entity. That doesn't happen here. There is no aid to private schools in this act. What you have is a tax policy that will offer a credit to certain donors. The path from there to the benefit of any final provider, whether it be a public school, and public school tuition is implicated here, and I don't think being challenged now if you cross county lines into the statute, or whether it be someone offering tutoring or providing laptops for low-income children, that you have all this law does is create the tax credit. And fundamentally, other than an amount, no different than the existing and unchallenged tax deduction. From there, before you get to any final educational service provider, you have to have a willing and voluntary donor who then gives it to a nonprofit that under this statute is then designated a granting organization that then makes it available to a qualifying low-income family. And then that family determines which of the various services available that they would want to use this money for. So there is no state action, there's no direct or indirect state benefit to private schools. But this is, again, what the Kentucky case law talks about as being child-centered aid. The state isn't deciding who gets the benefit of this program. It is low-income families in the day who decide how whatever funds are donated.
Or it's the
Under the
AGOs, I guess, that allocate the funding, because, they can certainly have, I guess, some control over how the money's spent, right?
They can, consistent with and within the framework regs, they can identify what kinds of services they'll make
Right.
opportunity accounts available for.
Right, right.
But even they don't then choose the provider. It's up to the low income family to make that decision for themselves. So again, I think that's a long way of, again, trying
But I
to.
guess if the low income family doesn't want to spend the money the way the AGO wants it spent, they're not going to get the grant from that AGO, right?
When again, Your Honor, that's no different than a tax deduction today. If I want to be a donor, I decide what charity I give to, and then that charity is free to decide its purposes and beneficiaries. Again, that's not a constitutional distinction. That already happens.
Yeah, I guess, again, the concern here, and again, I don't know if it's a valid concern or not, but the concern is that the money involved is money that is not just an act of philanthropy. It's money that was owed to the state as taxes.
Well, again, at the risk of repeating myself, Your Honor, there's no money owed until taxes are calculated and due. The credit becomes part of the formula
Well,
that is used to.
I mean, that's right. Okay.
And because it's tax policy in Kentucky case law, and we discussed in our brief, so I won't belabor it, is very flexible. The General Assembly has a lot of discretion as to how it might want to incentivize charitable behavior and giving using the tax structures. And that simply is not, not within the purview of any of the constitutional provisions that have been cited by the plaintiffs.
Yeah. Tell me, Mr. Thacker, what do you think if a tax credit of this nature had been proposed to the framers of the 1891 Constitution? How do you think it would have been received?
Your Honor, our job today is not to try to read the framers' mind. Our job is to read the text of the Constitution they've left us.
Right.
And that text does not prohibit this program. That doesn't say anything about it. So it's within the General Assembly's purview.
Yeah. Okay.
Your Honor, I don't want to step on Mr. Thacker's toes. I do have a direct answer for that. You can look at the Brown case, Brown versus Board of Education of Newport. That was decided in 1900, just after the convention. And again, it shows that Section 184 was in, and I can give you the quote here, the citation's at 57 Southwest 612. And the quote says, the text of Section 184 shows clearly that the intention was to prohibit the collection of any taxes to any extent for educational purposes other than common schools without the consent of the people. So again, taxes, this is a taxpayer protection provision. It's not an anti-private school, anti-school choice provision.
Okay. All right. Okay. Anything else, Mr. Thacker?
Your Honor, unless the court has further questions, I think that's it for me right now.
Okay, thank you. I guess at this point, let me go back to Mr. Harrington, and I'll let him respond to some of the discussion that we had.
Thank you, Your Honor. As you might imagine, I have a few thoughts. Okay, first, I think this is vital. The defendants want to litigate a different case than the one that we've brought here. They want to litigate a case about the constitutionality of a tax credit. We have asked for four specific pieces of relief. First, we asked this court to strike down Section 72B, which specifically authorizes aid to non-public schools. Mr. Thacker says that nothing in this statute provides aid to non-public schools except for Section 72B, which explicitly authorizes shall be permitted to use funds received through the EAO program, the program created by the General Assembly for tuition and fees to attend non-public schools. That is the General Assembly providing aid to non-public schools to pay for tuition. It is plainly unconstitutional under Fannin, and so we asked this court to strike that down. We also asked the court to order the Department of Revenue from carrying out the statute that allows for aid to non-public schools. So first, we ask the court to order the Department of Revenue to refuse to authorize any AGO that intends to spend AGO sums. These are sums raised by the General Assembly, the language of Section 184, in either in tuition for non-public schools or in services. Mr. Thacker, in both his brief and today, has characterized our position. If services are being paid to non-public schools, just like in Fannin, if for loaning books, that too would be unconstitutional. So the Department of Revenue should be ordered to not approve AGOs that are going to spend these AGO raised sums on non-public schools. And then 3, we ask this court to order the Department of Revenue to disapprove tax credits that are going to be spent on non-public schools. Again, Mr. Thacker says that we figure this out at the end of our tax season. That's not how this bill works at all. And the Department of Revenue can speak to this. They are going to approve tax credits. In fact, the whole timing of the briefing of this case is predicated on the October date in which they anticipate first approving tax credits. So the governmental involvement here is profound. And 4th, we're asking this court, and Your Honor, put your finger on this, to strike down the provision that specifically authorizes discrimination in the delivery of education services. Section 15 specifically authorizes discrimination. Section 15.4 specifically authorizes discrimination in this scheme. I can't think of another governmental benefit that the legislature can specifically license private entities to discriminate against Kentuckians, and certainly not on the basis of geography. You'll note, Your Honor, what we have not asked you to do is to strike down the tax credits. The defendants say that we will put in jeopardy every other tax deduction and tax credit in Kentucky. We're not even asking to strike down this tax credit. What we are saying is that the tax credit cannot be used to fund non-public schools. And there may be additional constitutional problems with the operation of the scheme after this court strikes down the aid to non-public schools. And Your Honor, put your finger on several of those issues on whether it creates a separate system. So we do think there may be additional constitutional problems, but we've been very focused and purposeful and only seeking to, and at least in our motion for summary judgment, to strike down the provisions that are facially unconstitutional. And again, that is the aid provision and the licensing of discrimination and the Department of Revenue's actions that will flow directly from the operation of the statute. Note, I think the first half of the argument of my opponent was these are all voluntary decisions, and then the second half was, the actual legislative language that creates the non-public aid, that's okay, even though it's discriminatory. We are seeking no relief from any private entity or any voluntary action. If a wealthy Kentuckian wants to set up a scholarship program like this, they are free to do that under any of the relief we're asking for. Our objections to the General Assembly developing a scheme and even creating the approval process, the creation of the AGOs, the funding of the AGOs, who can use what money for where, those are our objections. They're specifically to the state actions. I want to make clear something that I think we should just be very clear about who our clients are. Our clients are superintendents in school districts throughout the Commonwealth and individual parents and educators who care deeply about public education. There's been a fair amount of characterization of our views in this case. I think Mr. House did this, Mr. Thacker said that we object to education for low-income students. I just want to be really clear. Our clients, many of whom have committed their entire lives to educating students, including low-income students. We are here because we firmly believe that this dual system will harm students and low-income students. So I don't think it's fair to allow that characterization of our position to stand. And then 4th on this, Mr. Thacker, again, I feel like we're having two different conversations. At the beginning of this hearing this morning, he objected to amici introducing or sharing with the court their views about how voucher schemes operate in other states. And their learner experience is that they're actually harmful. And Your Honor has the brief. You can see it. They're harmful. They lead to discrimination. They do the things that Your Honor has referenced, which is they favor students with families from means. They favor students that have families with high social capital. Anyway, that's their policy story that they want to share with you. As you know, our actual legal claims do not turn on that policy debate. Yet, Mr. Thacker, at the one hand, says, don't listen to the amici, but on the other hand says, the scheme is saved because it will help Kentucky students. We just don't believe that's true. We don't think we have to show that. Once the General Assembly has
Well, I guess if that's an issue, that's something that is probably a disputed issue, right? I mean,
absolutely, Your Honor, and that's certainly the position that we took in our papers, that we think that as a matter of law is not legally relevant, but if it is, then we should have a factual dispute about that, and that's how it should be resolved.
okay.
And with that, unless the court has questions.
Okay. All right. No, but I guess I would like to hear a little bit from the Department of Revenue about where we are in terms of the process of the Department of Revenue's actions in implementing this legislation and what the timetable is. So I guess is Ms. Rice going to address that?
Yes, good afternoon. Bethany Rice, on behalf of the Secretary and the Commissioner. The department's website went live on September 8th, where the forms for the applications became available to be downloaded. To date, the department has received 3 applications, which the department is in the process of reviewing and considering. And it would like to state to the court today that it will not issue an approval before the October 11th date that it provided in the affidavit filed on July 2nd.
Okay. You're still on the same timetable that you all anticipated at our last.
That's correct, Your Honor. And we did note that your order directed us to notify the court within 20 days. And we'd like to ask you today if you would like for us to file a written notification to the court.
Yeah, why don't we do that, just so the record's clear on that? Sure.
Okay.
Okay, so the Department of Revenue has got a website up and running, and application forms are available, and you all have received 3 applications, right? Okay, anything else in terms of the implementation of the bill that is relevant to what we're talking about here today that you all want to inform the parties in the court?
Well, Your Honor, as you know, we didn't weigh in on the merits of the case, but we did notice that a question arose in the pleadings that we thought might be appropriate to address. And that the question was whether if the court were to rule the EOA program unconstitutional, to the extent it authorizes the tax credits for taxpayer contributions to an AGO for funding or subsidizing non-public schools, would that endanger other tax credits and allowable exemptions and deductions under Kentucky's income tax law? And our position is that no, it would not. We understand the question presented is whether authorizing the tax credits would contribute to for taxpayers who contribute to an AGO violates Kentucky constitutional provisions addressing the establishment and funding of Kentucky's common schools for grades K through 12. And if you were to determine that these constitutional provisions were violated, we do not believe any other credits, exemptions, or deductions authorized under Kentucky's income tax law would be affected because they are not related to primary education or schools providing primary education.
Okay, so your all's position is that the challenge to this particular tax credit is tied to the educational provisions in the Kentucky Constitution, and that would not be an issue on the other tax credits that are enacted by the General Assembly. Okay. Okay. All right. Well, this has been very helpful to the court. Does anybody else have anything they want to add before we wrap things up here? Let me ask, I guess we did have a couple of both the interveners and the Attorney General indicated that they felt like that the special legislation argument under section 59 of the Constitution had been waived because it wasn't explicitly set out in the complaint. I do think it was referenced in briefs on summary judgment, but I guess I'd like to get the plaintiff's response to that argument.
Yeah, Your Honor. So our view is that it was sufficiently raised in our it was in our topside motion for summary judgment, where we were very explicit about section 59. We think it was implicit in our complaint. If it needs to be made explicit in our complaint for this court to reach that issue, we think we should have leave to amend the complaint just to make that crystal clear. But we think that it's already implicitly included. And as you said, we raised it right away on the top side of the motion for summary judgment.
Okay. All right. Okay, anything else that anybody else wants to add? Well, this has all been very fascinating. It's interesting legal issues and a lot of reading material for the court, which I need to devote myself to now in the coming days and weeks and try to get you all an opinion. It's all been very ably briefed, and so I want to express my appreciation for for all the work that has gone into getting it before the court and briefed so well that it is obviously very helpful to the court to have these kinds of briefs. And I'll try to plow through them and get you all a ruling on these motions just as soon as I can. I'll, in light of the kind of timetable, I guess, that the Revenue Department has indicated, I'm going to do my best to get you all a ruling prior to October 11th. And I hope I'll be able to do that. And if I have any additional questions as I continue reading and studying the briefs, I may well ask you all to convene again to address any additional questions that I have in my review process. But absent that, I'll just take the matter under submission and try to get you all a ruling as soon as possible. Okay.
Your Honor.
All right. Thank you.
Yeah.
And we'll get a separate ruling out on the motion to file the amicus brief within the next couple of days, or maybe not tomorrow, but by the first part of the week. And then I'll go ahead and take the merits of the summary judgment arguments under submission. So, okay, thank you all very much. And we'll stand in